All right. Welcome, everyone. My name is Zarihun Haile Selassie. I am the 2025-26 FAR Vice Chair of the Board and the Chair of the Program Committee. We are truly delighted to have you joining us today, this afternoon, for our monthly webinar. Topics today's session is Ask the Nonprofit Attorney Everything You Want to Know, featuring one of the country's most experienced and notable nonprofit attorney, Jeff Tenenbaum. Jeff does not need any interaction, but his work and engagement with the nonprofit community are a testimony. His dedication and involvement with the nonprofit sector speaks for themselves. Through his ongoing commitment and all the support, Jeff has consistently served as a valuable resource for most nonprofit organizations, offering guidance, support, and have made everlasting throughout our nonprofit community. Jeff, thank you. I hope, assuming that you all are armed and with questions, and we're exploring the most pressing legal issues facing the nonprofit organization these days. This will be a Q&A. There is no prepared PowerPoint presentation. You're driving the conversation with Jeff, and as we encourage you to ask Jeff about anything about federal tax exemption, contracts, employment law, antitrust, AI usage policy, a lot more out there. And most importantly, you can just follow up from last year's discussion on DEI. We're still in that debacle that's going on with the DEI initiatives. Feel free to ask all those questions, and Jeff is prepared for you to provide guidance and answering your question. Before I turn to Jeff, I want to just quick reminder, please enter all your question in the chat. We will be monitoring the chat throughout the presentation. If you raise your hand, if you want to ask direct live, feel free to do that. So we'll let you to open up and ask question. Just want to remind, this is a recorded session. We encourage you not to be more specific on legal issues concerned about your organization unless you want to be on the public. This is a recorded session. If you have any question or interested to become a FAR member, please visit our website, www.far-roundtable.org, or email us at hqfarroundtable.org. Again, thank you for joining us today. Without further ado, I will turn it back to Jeff.
Thank you, Z. Good to be with everyone today. For those of you who have joined me or seen me on webinars and in-person sessions like this, like Z said, there's no prepared presentation or remarks here. This is all going to be driven by the nonprofit legal issues and questions that you guys have and want to hear about. I like to try to mix it up as much as we possibly can, try to ask questions on as many different legal issues. Z mentioned a few. Let me just kind of run down a list just to get your minds jogging on different topics and issues that you might want to ask about, whether it's a specific question, whether it's just an area of the law that you're interested in learning a little more about. Obviously, with 55 minutes here, there's only so much depth we're going to be able to get into, but I will try my very best to give you meaningful, substantive, practical answers to your questions in lots of different areas, everything from federal tax exemption and UBIT to contracts, meetings and events, corporate governance, bylaws, conflicts of interest, antitrust issues, employment law issues, regulation of lobbying and political campaign activity, anything involving nonprofit fundraising regulation, gift agreements, gift acceptance policies, gift restrictions, mergers, joint ventures, partnerships, subsidiaries, affiliates, chapters, governmental investigations. We're handling quite a few of those right now. Internal investigations, really anything under the sun, feel free to ask me about. Just so you know a little more background, I've been an attorney practicing law in private practice in DC for 30 years, all of it exclusively representing nonprofit organizations as outside counsel. Spent 20 years chairing the nonprofit practice at a large law firm called Venable. 6 years ago, a little over 6 years ago, started Tenenbaum Law Group with my law partner Nisha. We're now a 7-lawyer boutique. in DC, and all of our clients are nonprofit organizations. So we deal with a broad array of all of the different legal issues that nonprofits deal with. I have deep experience with most legal issues that nonprofits have to deal with. We work with hundreds of organizations, primarily national and international nonprofits each year, all different types. And so have a lot of experience to bring to the table, and that's the experience I'll be speaking from today. So, with that, someone needs to get us started on an issue, a topic, a question, something that you want to hear about. Post it in the chat, take yourself off mute, and raise your hand or whatever you would like to do. It looks like there's also, Z and Erica, some people are posting questions in the Q&A box, which is fine. So if you can just monitor both. But I'm looking at a couple right here. And by the way, if you ask a question that is highly specific and maybe not as relevant to the broader group, I might broaden it to make it a little more applicable, and or B, I might just have to pass on it and ask you to follow up with me directly. And one other thing, in a handful of areas of law that require very specialized expertise that I don't have and my six attorney colleagues at the firm don't have. We have a network of what we call outsourced counsel that are experts in these different areas that we rely on. One of those is immigration law, which is a very obviously hot topic these days. So many nonprofits are asking us immigration related questions. It's just not an area that I have personal expertise. And so that's an area that we outsource to a phenomenal immigration lawyer. So if it's one of those type of questions, like the one from Minneapolis, just please email me offline, and I'd be happy to connect you with Peter Assad, who would be happy to help you. And Z's going to post in the chat a couple links to our website, our firm's website, one to an index of all of our articles and PowerPoint presentations, hundreds and hundreds of them on every conceivable nonprofit legal topic. We're constantly posting new ones. They're in chronological order, so the newer ones are at the top. My colleague Holly Peterson just wrote a fantastic article about remote and hybrid workforce and how nonprofits can deal with the legal challenges in that area. It's an issue that presumably every single one of your organizations is dealing with. It's an area that's keeping us extremely busy these days, and it's a terrific article. I would encourage you to take a look at. But let's dive in. First question. A nonprofit executive writes books and owns the copyright. He has a royalty agreement with, I guess it means his employer and an outside publisher. Can the royalty agreement cause excess benefits? So this is a good question. I like it because it brings in a couple different areas of law, both copyright law and federal tax exemption law. So first off, let's deal with a copyright issue. So a nonprofit executive writes books and owns the copyright. Well, that's not necessarily going to be the case, or at least as a function of law, it's not going to be the case because the basic rule in U.S. copyright law is that, and all copyright law is federal, there's no state-based copyright law in the U.S., is that when an employee writes or creates a copyrightable work within the scope of employment, the copyright automatically vests in the employer. So in that example, if it's, say, the nonprofit CEO who's writing books while he's employed by the organization, and if he is writing on topics that are within the scope of his employment, unless there's an agreement to the contrary, which there could be, then the copyright in those books is automatically going to vest in the nonprofit organization, the employer. Of course, if there's a written agreement to the contrary, where the employer agrees to let to assign the copyright basically back to the CEO, then that's certainly permissible. But that's going to be an important distinction of who owns the copyright, who has the right to register the copyright, etc. And then the second part of the question says he has a royalty agreement with an outside publisher. So presumably outside publisher publishes the books, sells the books, and then makes money off it and pays a percentage to the author as a royalty. Can the royalty agreement cause excess benefits? So, here's where we get into the federal tax law issues. And this has to do with the private inurement doctrine, which applies to all tax-exempt organizations, and then potentially the private benefit doctrine, which only applies to C3 and C4 organizations. Now, the private inurement doctrine, which the term excess benefits is generally related to that, because for C3 and C4 organizations, if private inurement occurs and there's what's called an excess benefit transaction, the person or people who benefited from that excess benefit can be assessed penalty taxes. Those are generally called excess benefit transactions. Again, those excess benefit penalties only apply to C3s and C4s, even though the private inurement doctrine applies to all exempt organizations, including C6s. But what both the private inurement doctrine and kind of the corollary excess benefit penalty taxes, they all relate to the organization paying something or giving something of value to the individual, to what's called a disqualified person, like an officer, director, employee, someone who has an ability to exercise substantial influence over the organization. If the organization is not paying anything, like here the royalties are coming from an outside publisher, there can't be any private inurement because the organization's not paying anything to him. So it can't cause an excess benefit transaction. Now, on the other hand, if this were a C3 and a C4 or a C4 organization, which is governed by the private benefit doctrine, which is much broader and different, it's kind of related, but it's very different. It has nothing to do with the organization paying something to the individual. It has to do with basically an individual such as the CEO benefiting too much from, in this case, his employment by the organization and basically the benefits of the organization going too much to him compared to the general public. Conceivably, theoretically, that is a situation that could trigger some concerns under the private benefit doctrine if the organization were a C3 or C4. All of that being said, it is not uncommon, and we work on a lot of nonprofit CEO employment agreements, probably work on 150 a year. And there are certainly instances, particularly with larger organizations, where the CEO negotiates as part of the deal with the employer that they're allowed to do some outside things. Think like teaching a class at a university, serving on a for-profit board and getting paid, writing books, and things like that, where the employer agrees up front that yes, this is not going to take away from their principal job duties. They're still going to perform full-time work, but they're allowed to do these things on the side. As long as you have that sort of arrangement, I'm not concerned about any private benefit issues if the organization was a C3 or C4. Okay. Next question. Do you have any insights on the recent letter from the Attorney General relating to nonprofits that receive federal funding being required to no longer have DEI efforts? I have a lot of thoughts on this. I just did a webinar yesterday for an association and basically for all of their chapters on how they can mitigate their risk from their DEI initiatives. So let me explain this. I've done entire webinars, maybe even did one for FAR on this topic. I can't remember, but again, I have to really compress this. So in the DEI space, like I said yesterday on this webinar I did, not all DEI that nonprofits engage in is illegal, but not all DEI is legal either. And it's really important for everyone to understand the distinction between what's legal and what's not legal, because otherwise you run the risk of either overreacting or underreacting to current legal risks in this area. Now, also, let me say the law is evolving in this area through litigation and enforcement actions, particularly from the administration and a number of red state attorney generals in this area. So it's going to continue to evolve. And there are some things where we have some lack of clarity, such as there's a gap between Justice Roberts' 2023 U.S. Supreme Court decision involving affirmative action and something that Attorney General Pam Bondi said in a July memo from last year that she issued, having to do with proxies for race. And that stuff is going to continue to evolve and play itself out through the courts. But what we know right now is that in the DEI space, there are kind of three areas of legal risk that you should be concerned about. One is the use of federal funds. If you receive federal funds, it is illegal under Title VI of the Federal Civil Rights Act of 1964 to use those funds in a manner that discriminates against anyone on the basis of race, color, or national origin. Just those three protected characteristics. In these days, in the eyes of the current administration, federal administration, what we're really talking about is reverse discrimination, because that's what the administration is focused on. And that's what they're enforcing. They're not enforcing traditional discrimination for the most part. They're enforcing reverse discrimination. Now, it doesn't mean that if you receive federal funds, that everything you do is covered by Title VI. It's only the use of those funds and how you spend those funds. So how you spend those funds directly, and if you're like a subrecipient, a subgrantee, a subcontractor of federal funds, this is going to apply to you as well. You need to make sure you're not using those funds in any way that discriminates against anyone on the basis of race, color, or national origin. Second area of legal risk is employment, and this is a big one. I'm sure that most, if not all, of your organizations have employees. And in the employment area, this really started in earnest about almost 3 years ago with the June 2023 U.S. Supreme Court decision involving Harvard and UNC that banned race-conscious college admissions practices. And that decision, while it only applied to college admissions, adopted this kind of reverse discrimination line of reasoning, which has now been utilized by plaintiffs and regulatory enforcement agencies in the employment space, and in the third category that I'll get into it in a moment involving contracts. But in the employment space, we're seeing a rash of litigation which has increased many times over after last summer's unanimous Supreme Court decision that held that members of a majority group, think straight white males, for instance, who bring a discrimination claim, essentially a reverse discrimination claim about employment discrimination. It used to be that members of majority groups had to meet a much higher procedural bar in order to get into court, and it was very difficult to meet that bar. The U.S. Supreme Court threw that out. They said that's not correct. Discrimination is discrimination, whether it's from a member of a majority group or a minority group, and there should be no higher bar. That has opened the floodgates to a bunch of reverse discrimination employment litigation by majority group members. And that's really notable and really important. So any employment policy or practice that gives any sort of preference to, people based on their protected characteristics, gives preference in hiring and promotion, in anything in the workforce that discriminates arguably in any way on the basis of any protected characteristic, and there are many protected characteristics under federal and state law. And remember, state employment laws like discrimination laws are going to apply based on where the employee is principally working from. So we have some clients that have employees in 40 states, and they have to deal with 40 different states' employment discrimination laws and other employment laws because they're going to apply to those employees based on where they're located. You need to be really, really careful about that. And in addition, Pam Bondi has now put out a couple memos regarding that touch on this concept of proxies for race. So it's not just classic racial discrimination or discrimination on the basis of other characteristics. But for instance, Pam Bondi said in one of her memos that, if you are, primarily recruiting employees only from historically black colleges and universities, even though historically black colleges and universities do admit non-black students, that she views that as a proxy for race, and that can constitute a racial discrimination claim in the recruitment and hiring process. So you need to think broadly about these things. But it's a very, very significant area of legal risk, and the employment laws can be enforced by the two primary federal agencies, the U.S. Department of Labor and the EEOC, both of which are doing so. They also can be enforced by state departments of labor. Each state has a different name for it, and they can be enforced by private plaintiffs in litigation and things like EEOC charges and whatnot. And every state has a mechanism for those things as well. So that's the second area of big legal risk. The third area of big legal risk comes from, believe it or not, what's called Section 1981 of the original Civil Rights Act of 1866, which makes it illegal to discriminate in contracting on the basis of race. And the same gentleman, Ed Blum, who brought the two court cases that led to the 2023 U.S. Supreme Court decision, after that decision, he formed another conservative nonprofit called the American Alliance for Equal Rights and started filing lawsuits against primarily nonprofits that were offering grants or scholarships or fellowships, all of which had eligibility criteria where race was one of the eligibility criteria. And again, remember Section 1981 of the original Civil Rights Act, which was enacted at the end of the Civil War to ensure the rights, try to ensure the rights of the then freed slaves to be able to earn a living, makes it illegal to discriminate in contracting on the basis of race. Ed Blum's argument is that these grants, scholarships, and fellowships all involve a contract. And if you can only be eligible because of your race, and race has been interpreted to include ethnicity as well, then that's illegal and a violation of Section 1981. There was a First Circuit Court of Appeals decision in a preliminary decision involving the Fearless Fund, a nonprofit out of Atlanta, which basically said the plaintiffs had a substantial likelihood of prevailing on the merits. The result of that was that Fearless Fund backed down and abandoned their program. Most of the other lawsuits that Ed Blum's group, American Alliance for Equal Rights, has brought, along with another conservative nonprofit called Do No Harm, which is focused more on healthcare associations and nonprofits, similar type cases. Most of the defendants in those cases have changed their eligibility criteria to eliminate race as one of the eligibility criteria to get the grant or scholarship or fellowship. Some have abandoned their programs. Some of these groups also have filed complaints with federal agency offices of civil rights. Ed Blum's group filed complaints with the IRS about the Bill and Melinda Gates Foundation for their signature college scholarship program. The Gates Foundation, by the way, a few days later changed their eligibility criteria to make it solely needs-based. And so this is another, I could go on about this for a long time. But the reality is that if you have a grant or scholarship or fellowship program where race is one of the eligibility criteria, it is likely illegal. And you're going to want to make efforts to change those criteria to eliminate that and be sure you're not using proxies for race. So those are kind of the three big risk areas. Outside of that, and this is what I told the folks on the webinar yesterday, there are a whole host of other things in the DEI space that you can do that don't fall into any of those three buckets. And so if they don't fall into any of those three buckets, they're likely legal. And so things like, having, interest groups, for your members. I'm not in the employment setting. That's different. Pam Bondi has said, and the EEOC has said that, I think it was EEOC guidance that said on the employment side, if you have like groups that are organized around certain protected characteristics, that has the potential to create a hostile work environment for other employees that don't fall into those groups. And that can be illegal under the Title VII of the Civil Rights Act, the principal employment discrimination law. But in the member setting, you can do things like having interest groups organized around certain protected characteristics. You can have, goals for your board, diversity goals that, target people of certain protected characteristics. You can have, DEI programming at your conferences and meetings and webinars. You can put out issue papers on these issues and policy papers and advocacy. You can do all of these things, particularly when it's, involving just members and board members and committee members, having, building DEI into your strategic plan. None of that should violate current law. And that's important to keep in mind. However, in the 36 or so DEI audits that we've done for our nonprofit clients, we have in every instance said, while those sorts of things don't violate the law, at least current law, that they can create other risks for organizations, business risk, financial risk, risk of sponsors and members and donors and advertisers and exhibitors pulling back their sponsorship, their payments, their monies from your organization, having people boycotting your conference because it has too much DEI content. These are all real life things that we are seeing. Also reputational and targeting risk of being targeted by the administration. So there are a lot of nonprofits that have pulled back their DEI initiatives, not because they're illegal, but because they create some of these non-legal risks. And that's something you definitely have to factor in to your risk analysis and balance it against your risk tolerance. I know that was a lot, but I know that's a hot topic. I'm not going to go back to that anymore, but hopefully that would that'll do. Erica, I know there's a lot of questions, so why don't I turn it over to you to tell me what you want me to answer next?
All right, let's see. We have a question that involves, okay, here's one. If a small 501c6 nonprofit enters into a licensing agreement with a third party for-profit service provider that is unpopular with the current administration, is there an increased legal risk that the agreement will be challenged by the IRS as creating UBIT or as inconsistent with a nonprofit status?
Okay, I'm going to take the speaker's liberty to broaden that question a little bit and also to direct you to a couple of resources. So first off, there's I think it's a great article. I wrote it, but it's about UBIT, unrelated business income tax for nonprofits. And it's a pretty comprehensive article that gives a good overview of the UBIT rules generally, and then does a deeper dive into three of the core exemptions from UBIT: royalties, corporate sponsorships, and qualified convention and trade show revenue. So that article, if you read that and compare it against your facts in your situation, it should help you answer the question about whether that arrangement, that licensing arrangement, is going to give rise to unrelated business income. The key is if a license is when you typically in the nonprofit world, when you're letting someone else use your intellectual property, like your name or your logo or your copyrighted information or other trademarks. And generally, if you are allowing someone else to use your intellectual property in exchange for a fee, that's going to be considered tax-free royalty income because it's passive income. You're just letting someone use your IP, getting paid for it. That's tax-free, unrelated business. I mean, that's tax-free royalties. But if, as is often the case, that company asks you to also say it's an endorsement program and they're asking you to actively market that product or service, say it's an association to the association's members or donors or whatnot, or an affinity credit card that's being marketed to, the charities, supporters and donors. If you're going to do some sort of active marketing, for instance, in addition to the licensing, then some portion of that fee is going to have to be treated as taxable unrelated business income because that's a marketing fee. You're getting paid for marketing the products or services of a for-profit company, which does not fit within the royalty. But some portion of it, likely the largest portion of it, will still be able to be treated as tax-free royalty income. In terms of risk from this administration, and I said this to a client yesterday, which was considering, because it's a nonprofit that is very much engaged in kind of social advocacy on, let's just say, very left of the political aisle issues that say do not align with the current administration's priorities, to put it mildly. And they were asking me about potentially whether they should relocate, basically they say move their like incorporation status like outside of the U.S. or something, which is not possible to do, but it's always possible to create a new entity outside the U.S. and, if possible, grant your assets. That's not always possible to do. That's a whole other discussion. But what I said is that, and I just said this in an interview with the nonprofit Times recently as well, that we have not seen, with a few exceptions, there is this current criminal investigation of certain groups that the administration labels as Antifa, which is basically a movement. It's not a particular, it means like anti-fascist, but there is this criminal investigation into certain Antifa-related organizations that the administration is apparently investigating as to whether they are, fomenting violence and things like that. That's a very narrow subset of nonprofits that really is not going to touch the folks that are on this call today. Outside of that, we are seeing, well, with one exception, big exception being federal funding. We have seen federal funding, especially grants, being cut for virtually every organization that doesn't align with the administration's priorities. And I don't see those funds coming back during this administration. So that's clear. That's already happened. It does continue to happen. There are some organizations that has surprised me, though, that some of our clients, that have conservation purposes and other things that are still getting monies from, grants from federal agencies. But for the most part, and there's a lot of litigation going on about that, as I'm sure you've seen. But outside of federal funding, we have not seen any evidence of any sort of enforcement by the administration, like going after and targeting, again, with a few exceptions, targeting organizations using the levers of the federal government because of their positions on different issues. And we're certainly not seeing any IRS crackdown, like audits or other crackdown on organizations, outside of this criminal tax enforcement that I referred to, based on their viewpoints or whatnot. Federal funding, different. You're seeing all the cuts to, and litigation against Harvard University, for instance. But my point is, I am encouraging clients and others to not overreact to the current climate, particularly when it comes to IRS enforcement. All right, let's try to tackle some other issues. But there are a couple of issues that I see here like there's a question about House ethics rules that my colleague Kevin Serafino can definitely answer. I just am not up to speed on those issues the way that he is. So for that question, if you just want to email me directly, I'll loop in Kevin and be happy to get back to you. There's also a question about clergy compensation that we really just do not deal with religious organizations. So I am not an expert in that area. I do have someone I could refer you to. Let's see. If the board wants to hold a monthly Zoom call with the executive director, should the organization prepare minutes for each monthly meeting, even if the meetings have no formal agenda or voting on action items? I think generally speaking, my answer would be no. These days with the amount of litigation and investigations going on, and I know some of you have direct experience with it because you're living and breathing it every day. We're dealing with a lot of these right now. Um, for meetings like that, which are, generally speaking, if you have written records, meeting minutes, emails, anything like that, and you get hit with a subpoena, whether it's a third party subpoena or you're a defendant in litigation or you get, there's a lot of investigations going on by congressional committees and subcommittees. The general rule is if you get a request you have responsive documentation or information and it's relevant to the request applies to it, you have to provide it. And there are some exceptions where you might have a legal argument for redaction of certain things, certainly anything that's privileged, subject to the attorney-client privilege. But other than that, you're going to have to provide it. And lawyers, including myself, get rightfully concerned when there's a lot of sensitive information being discussed on those sorts of calls, where we would prefer there not to be a written record of that, whether it gives rise to legal risk or political or reputational risk, public relations risk, whatever. Generally speaking, as a general rule, meeting minutes should certainly be kept of official board meetings and committee meetings, but meeting minutes in those instances should not be a recital of everything that was discussed during the meeting. It should just say, the board discussed, I don't know, details of an upcoming program, period. It decided to, charge the CEO with moving forward and doing due diligence on the next phases, and it voted unanimously to approve the motion, period. Like that's all it should say. Not he said this, she said this, he said this, she said that. Too often we see meeting minutes that are way, way too detailed. And for this particular question about the monthly Zoom calls with the executive director, generally speaking, there should be no minutes kept of that. Should associations be concerned that corporate sponsorship will result in favoritism for sponsors, like access to do more workshops? Would this be unfairly excluding companies that are not sponsors? Uh, this is not a legal issue, and this is kind of reality. It's just the way, especially in the association world, it's kind of the way it works. That yeah, in some organizations, this is no secret that you know they advertise in one of our clients, the Association of Corporate Counsel. There, it's kind of a pay to play model, and the only way that you can even be on the panel at their programs, that way that you can be a speaker on a webinar or seminar, is if you're a sponsor. That's the only way you can do it. If you're like a for-profit company, like a law firm or whatnot, or another service provider or vendor, that's the only way to do it, and it's not illegal. It's, some associations and nonprofits have that practice, some don't. The reality is, even ones that don't have a formal structure like ACC does, some are going to give more preference to sponsors. It's just the way of the world. I tend to not weigh in on things if they don't have a legal issue involved with them. Whether it's unfair to companies that are not sponsors, that's really not for me to say. But I do know that, generally speaking, particularly associations that do a lot of conferences and events and meetings and things like that, and we work with hundreds of them. They're trying to get the best speakers and the broadest array of speakers and a diverse array of speakers and people that have varying, different areas of expertise and whatnot. And you're not going to get that just from your sponsors. And I generally have not seen that be a big concern or issue. If there is a FOIA request for AI prompts, would this be a valid request since these prompts are not final documents? I don't really have an answer for that specific question, but I'm reading it because we see all the time our clients come to us with questions about FOIA requests. Keep in mind, FOIA, the Freedom of Information Act, only applies to governmental agencies. You can only issue a FOIA request to a governmental agency. You cannot issue a FOIA request to a private nonprofit. It just doesn't apply. It's apples and oranges. Now, you can issue third-party subpoenas to private nonprofits. I talked about those earlier. Third-party subpoena meaning that it's typically in connection with litigation. Sometimes it's not. Like one of our clients got a subpoena. I guess not a third-party subpoena, but they got a subpoena from the California Attorney General's office recently, looking for a whole bunch of sensitive information. To us, it seemed like a political fishing expedition. But regardless, that's not a FOIA request. Now, one thing that is relevant is, and we're dealing with this with some governmental investigations right now, that if you as a private nonprofit provide certain documentation or information to a government agency, then in some cases that document or information is going to be subject to FOIA requests if that governmental agency gets a FOIA request. And there are different bases for when that can be withheld. Right now, we're dealing with one for one of our clients where we're telling the Department of Interior that we ask that you not disclose XYZ documents because it contains sensitive, like business information about the nonprofit, sensitive business information. And that is a basis for the agency to withhold. But other than that, FOIA does not apply to private nonprofits. This is a related question to the meeting minutes, and we get this all the time. And this is kind of an area that's evolving in terms of the advice. Given the recommendations currently being given on meeting minutes, being brief summaries, does this mean that you recommend turning off any recordings, including AI note takers? So this is a tough one because AI note takers are so popular these days, and they make it so easy to just obviously record the whole thing, to do a summary. They're so talented and skilled at doing that. So it's very attractive to a lot of people. And look, there are sometimes I'm on, the video calls all day long with clients. And there are sometimes that clients say, do you mind if we, put on our AI note taker, or sometimes even record the call, but especially the AI note taker. So we have a reference of what you are saying and we can rely on it later. We can share it with others. And I am absolutely fine with that. And I think it's really helpful and it's efficient. And for instance, if I spend an hour going through a detailed, I just did this morning with a client that's considering setting up a for-profit taxable subsidiary. And I gave them some really helpful advice that they're going to rely on and share with their CEO and ultimately share with their board. If they use an AI note taker to capture that advice, later they don't have to come back to me and say, Jeff, would you guys draft a memo providing your advice on this issue, right? Which can save a lot of money. So there are lots of good reasons for doing so. But what I always say is you want to make sure that you label that as privileged and confidential, that you make sure you don't share it, that the attorney-client privilege applies whenever an attorney is giving legal advice to a client. And the client, when it's, say, a nonprofit, will typically be comprised of the officers, the directors, and the staff, and other legal counsel. And then sometimes if like the attorney brings in, a forensic accountant or a consultant or a crisis communications firm or something, which we do all the time, and the attorney retains them, then they can also be subject to the privilege. But if you share that with anyone outside of that control group, then it defeats the attorney-client privilege, and then all of that is subject to discovery, subpoena, things like that. And so what I always say is just make sure you label it privileged, you keep it secure, and you don't let it get out there. In terms of meeting minutes, I am really not a fan of turning on AI note takers for any sort of board meetings or committee meetings, unless and except the only reason is for the person taking minutes to be able to rely on it to assist them with the meeting minute preparation, and then it gets deleted afterward. And just for years, we've had clients that record, did like audio or video recordings of board meetings for the purpose of creating minutes, but then they deleted them afterward. And so that's been kind of our advice. How can volunteer leaders protect themselves and/or the organization while fighting for industry issues in the current environment, in this current administration? Yeah, look, there's no silver bullet here. There's no question. We've heard that the administration keeps a list of every nonprofit that sues the administration. In fact, we have one client that joined a lawsuit on this past Monday morning against the administration, and they had to take that into account in deciding on whether to join this lawsuit. Um, because, you essentially get put on the administration's enemies list. And their board, we had an emergency board meeting about a week ago, and the board decided that yes, we're going to move ahead, and it's really important and goes to some of our core values and principles, and we're going to join this lawsuit. Others have decided not to join lawsuits for that exact reason. Similarly, if you're going to be out there and vocal and advocating on issues that don't align with the administration's priorities, can that create some risk of losing federal funds or not getting federal funds in the future, or potentially being targeted in other ways, which again, we're not really seeing. But it's certainly possible. And just like I gave you the advice on the DEI front, what you want to do is take all of those considerations into account: legal risk, non-legal risk, targeting risk. Like in the DEI area, this nonprofit Do No Harm, they sometimes will find like a certain association or nonprofit that's, has certain DEI initiatives. And even though they're not alleging anything that's being done is illegal, they will plaster them all over their website and make them kind of a target and encourage people to, like, boycott them or do other things, to not donate to them or things like that. You have to take all of that into account, but then you have to balance it against your core values and your risk tolerance. With the hospitality industry becoming more difficult to negotiate with for meeting and event space, any specific areas to be aware of or push back on getting a contract signed, for example, force majeure? Um, I can speak to this a little bit. My law partner Nisha and a couple of our associates who do most, if not all, of our hotel and convention center contract and other meeting vendor contract review work can speak in a lot more detail and give you a lot more really meaningful advice. But a few things that I've seen and especially learned through Nisha over the last few years. By the way, we started our firm in January 2020. COVID hits 2 months later, and part of the reason for our rapid growth in 2020 is that I had done a webinar about hotel and convention center contracts in the COVID era and how associations, in particular, this is for ASAE, could use the force majeure clause to get out of attrition and particularly cancellation penalties in connection with their hotel contracts. And we brought in about 150 association clients in 2020 who we helped with that. And in 2020, we had a massively high success rate, maybe 99%, in getting associations out of their hotel and convention center contracts without penalty based on force majeure, with the hardest place being Florida, where it was extremely difficult to negotiate those settlements. Since then, though, just like it has happened in the past with other events like hurricanes and fires and things, hotels have very much tightened things up when it comes to force majeure. Force majeure is it's a common law contract concept, but it's also codified in most contracts, saying like if it becomes illegal or impossible for you to perform under the contract, then you can get out of the contract without penalty. But hotels and convention centers have very much, and in the past, we could often get language that said if it's commercially impracticable, basically meaning like if it doesn't make financial sense to hold the meeting, then we can get out of it. It's virtually impossible to get commercially impractical language into a force majeure contract anymore. With maybe the exception being, we have some very large associations that have citywide meetings. They work with the CVB and they take over, 15 downtown hotels. When you have that kind of leverage, you can get away with more. You can often get away with, no attrition penalties or very, very low attrition penalties. Attrition penalties are where you don't meet your minimums for, sleeping rooms and or food and beverage. But basically, hotel contract negotiations have gotten a lot tougher since COVID. And I've been doing this for 30 years. Like I said earlier, for years and years, it was a lot easier to negotiate things. They've just really tightened things up. But there are things that you can do. For example, for your attrition penalties, what you want to do is you want to make sure that the hotel is calculating attrition based on the total say it's a 4-day meeting, that you're looking at all 4 days and doing it in the aggregate and determining what the attrition is, not on a nightly basis. That can be more beneficial to the association. For cancellation penalties, generally you want to try to negotiate so that at certain periods of time leading up to the meeting, you have an ability to, but for attrition as well, actually, especially for attrition, to be able to reduce your guaranteed minimums, generally up to maybe 10 or 15%, at certain dates. And you want to try to negotiate that. And then, so if you're seeing that it's looking like, you're going to have fewer attendees, that you have an ability to reduce those amounts by a certain percentage, and that can help with your attrition. Other things, we have a lot of success with like remodeling, or like, a key restaurant or a pool being closed or things like that, and being able to get out of the contract if that happens. There are a lot of other things that we can still be successful with, but bottom line is the negotiations have become a lot more difficult. And if you're not a very large meeting and conference, you're going to have less leverage. Um, Many bylaws designate Robert's Rules of Order as a parliamentary authority for board meetings. Candidly, I hate Robert's rules, which are probably necessary for large assemblies, but in my experience, get in the way of good discussion with boards or smaller groups. I've heard from some lawyers that they are now recommending not designating any parliamentary authority in the bylaws. Are you a fan of this approach? Yeah, and I won't say your name, but I know who you are, obviously. Yeah, you know what? To be honest, I've never been a huge fan of Robert's rules. It can serve a particular purpose, especially for membership meetings. And by membership meetings, I'm also including one of my least favorite things, houses of delegates, which still exist. Anyone who works in an association that has a house of delegates, you know how much you hate the house of delegates process. It's basically a membership meeting with a representative group of members. But I've been at many house of delegates meetings, many full membership meetings, and they're having Roberts or some other leading parliamentary procedure is really helpful, because you have to be able to regulate that. Otherwise it just gets unruly. But for board meetings, generally, and I've been at more board meetings than I can ever count over the last 30 years, they utilize the basic elements, the core elements of Roberts, like about quorum and about motions and about seconding and about amending motions and what's on the floor. And generally, they don't use Roberts much beyond that. And in those situations, Roberts really, to me, doesn't get in the way of, good, healthy, effective governance. To me, where I would have a problem with it is if your nonprofit has a history of Roberts getting in the way of efficient governance. And I would say the same thing, by the way, even much more so about bylaws. And we do a lot of bylaw reviews. We're probably working on 5 or 6 in any given week, for nonprofits, all different types, both those with members and without. And to me, that's a much bigger impediment to healthy, effective, efficient governance than Robert's rules is bad bylaws. And sometimes those bylaws can only be amended by the membership at their annual membership meeting or the annual House of Delegates meeting, which can be really difficult to do in a lot of instances. Those are our least favorite situations. And right now, Nisha and or I are working on probably a half dozen different kind of major governance overhauls for nonprofits to overhaul their bylaws, generally working with some sort of a governance task force or governance committee, to overhaul the bylaws as well as other key governance policies. And, all of it, of course, some of it's, with an eye toward legal compliance, but most of it's with an eye toward creating a more efficient and effective, and successful governance process for the organization. There's a question here about a DAF sponsor, a donor advised fund, and a limited partnership unit. That's kind of outside of my wheelhouse. I'm not going to be able to answer that. The 100K H-1B visa question, if you want to email that to me, I will pass it on to our outsourced immigration counsel, Peter Assad, to answer that, because that's outside of my wheelhouse. As a private foundation transitions to a public charity under, and then he cited the Internal Revenue Code section, walkout, is it a public charity during the 5-year period? It's a good question. We're dealing with it right now for a client, and I don't remember the particular details without going back and looking them up. But what I will say, so let me just explain for everyone's benefit real briefly. all 501(c)(3)s are subclassified as either private foundations or public charities. You are by default a private foundation unless you can prove that you meet one of the three, technically four public support tests, meaning that you get your money from lots of different sources. And it's much more favorable to be a public charity than a private foundation. And I'm not going to explain why, but there's all these restrictions and prohibitions and limitations on private foundations to prevent abuse because the monies typically come from, one or two major sources, like a big donor or a corporation or a wealthy family. And so it's much more beneficial to be a public charity. And generally, you prove that public charity status. And when you start a new organization, the IRS gives you 5 years to prove it. And you basically need to show that you get your money from multiple different sources. The two primary public support tests, 509A1 and 509A2, this is for C3 organizations, of course. You reflect how you meet one of those tests on Schedule A of the Form 990. But then I want to use this question as an opportunity to talk about the third public support test, which is the supporting organization test. And this is really important. By the way, there's an article on our site about related foundations of associations if you're interested in this area, it's a really comprehensive article. It gets into a lot of these different issues. There's also kind of a companion article. I referenced taxable subsidiaries of nonprofits. There's an article about taxable subsidiaries that's similarly very comprehensive. I encourage you to take a look at. But the supporting organization test basically says that, and we use this all the time when you have a 501(c)(6) trade or professional association that has a 501(c)(3) related foundation. And sometimes the related foundation doesn't get its money from lots of different sources. Maybe just living off of a big endowment or investments, or the association is largely supporting it or has one big donor. And in those situations, if it qualifies as a supporting organization, then you look to the supported organization, the C6 organization, for instance, to see if it itself meets one of those first two public support tests. And if it does, then the C3 can be a public charity by virtue of being a supporting organization. And to be a supporting organization, either the C6 has to have the ability to appoint a majority of the board members of the C3, or there has to be majority overlap in board members on the C3 board compared to C6 board members, majority overlap. And it's a really helpful tool that can help the C3 obviously be a public charity, which is beneficial, but also it's kind of a legal excuse to have the C6 exercise more control. But what this question relates to is transitioning from a private foundation to a public charity. And the one thing I do remember is that you can't leave that private foundation status and become a public charity unless you have 5 years of demonstrating that you meet one of those public support tests. And we looked into it recently. There's some very strict rules in this area. It's not easy to do because we have a client that it's a C6 that has a C3, but the C3, unknowingly to them, they weren't aware of it. It failed after a period of time, the public support test, and they became a private foundation. And now they're trying to figure out how to transition back because there's a lot of money in there and in assets, and it's just not an easy thing to do. We did come up with, I think, a creative solution for them. But anyway, that's about all I think I'm going to say on that question. And then the only other question I see relates to clergy compensation wages, which is, like I said, we don't deal with religious organizations. So that is not in my wheelhouse. So I'll have to pass on that. If you have any questions that you want to follow up with me on, we have a fantastic religious organizations nonprofit lawyer who I can refer you to. So Erica, I'm not seeing any other questions. Does anyone else have any other questions that they want to ask? And Z, I'll put you on the spot. If you have anything, we got 3 minutes left. Any other final burning questions on any topics? This was great. We got into a fair amount of different topic areas, which I wanted to do. And those are great questions. If anyone has any follow-up questions, always feel free to reach out. My email address is on our website, easy to find. I do encourage you to take a look at those articles. Especially Holly's been cranking out some phenomenal articles on employment-related topics. Like I mentioned, the new one on remote and hybrid employees, which I encourage everyone to read. We've gotten a lot of interest in that one. I think it's going to be picked up and published in a lot of different places. Erica, feel free to publish that in your newsletter as well if you want.
Thanks, Jeff.
But she has articles on all sorts of discrimination and internal investigations, which we do a lot of, and so many other great employment-related topics. But we got stuff on there just about everything. So I think with that, I will wind it down and turn it back over to you guys, Z and Erica, and thank everyone for all of their terrific questions today. Oh, wait, we have one more question. Actually, this is a good one. We didn't have too many questions about contracts generally. So in the final 2 minutes, do you think it's a good practice for a small nonprofit to eliminate auto renewal provisions in contracts it executes? Just dealt with this exact issue for two different client contracts, two different clients in the last couple days. Short answer is it depends. It all depends on the nature of the contract and whose advantage it would be to auto renew or not auto renew. One of the things that we see a lot, despite the fact that there's a lot of good contract management software out there that you should be using, even for a small nonprofit. I mean, if you only have half a dozen contracts a year, that's one thing. But for most of you guys on this call, that is absolutely not the case. And you need to have a good contract management system that tracks everything, tells you when the term, that's the length of time of the contract, is going to expire, whether it auto renews. Because sometimes if it does not auto renew, that can be bad news for the nonprofit. Sometimes if it does auto renew, you wouldn't catch it, and it's another 5-year term that you're stuck with. Like we do a lot of big, like for instance, publishing contracts for, a lot of medical and scientific and educational associations and nonprofits that have scholarly journals and whatnot. And these are huge contracts. Same thing goes for big technology contracts for like an association management system and things like that. And sometimes, if you don't, give you the right to terminate with, say, 60 or 90 days prior written notice. But if you don't, it might automatically renew for another 3 years or 5 years. And if you want to get out of that contract and you can't prove material breach, that can be a huge problem for you. So it really depends on the situation. You want to be very deliberate. We review probably 50 contracts a week for different nonprofits, and every one of them is a little bit different in that regard. And we usually flag that issue and tee it up. Do you want this to auto renew? If you do you want it to just auto renew for a year? Now, of course, if it's a contract that lets you terminate at any time with prior written notice, like you can terminate at any time with 90 days prior written notice, then it's a moot point because it doesn't matter if it auto renews. But if that's not the situation and you cannot, you can only terminate, say, 60 or 90 days prior to the end of the term, and that's a big distinction. I was talking to a CEO a couple of days ago about something like that, and I asked him, which one is it? Because I hadn't seen the contract yet. Can you terminate at any time without cause with a certain amount of notice or only before the end of the term? And he wasn't sure. That's a critical distinction, and that's going to factor into your calculations as well. All right, I will wrap it up there. Thanks everyone for your great questions. Thanks FAR and Erica and Z for having me, and I'll turn it back over to you guys.
Thank you, Jeff. This is
Thanks,
very
Jeff.
insightful and very informative session. I know we're at time, and thank you everyone for spending your afternoon with us. And if you are interested to be the FAR future events, please visit our website. Our next event is coming up April 8th, risk on management and cost reduction idea for benefits, recruitment, and human resources. We hope to see you on that future events. And with that, again, thank you for your participation. Hope to see you on the future FAR events. Thank you, Jeff, as well.
Thank you, guys. Take care.